my lord, on the instructions, the Tennyson and Lowe.
May it please you, my lord, I appear on behalf of the 6th to the 8th defendants, and I'm instructed by Mr. Ellis of Ellis and Partners. It's a privilege to be before you, my lord.
Who's this?
I beg your pardon, my lord.
Who's this?
My lord, I'm Frank Balsa. I'm from the Cape Bar. I beg your pardon for not introducing myself to you earlier in chambers. I have appeared previously before your lordship.
Oh, okay. If you have appeared before me, yeah.
As a court pleases.
Yeah. We're getting younger, so memory. Yes. All right.
My lord, before we start, I hand up to your lordship and the other parties give one to each of the other parties and one to the judge. I beg leave to hand up a schedule of time allocations, my lord. Which we propose your lordship makes a ruling on to give each set of legal practitioners.
You want to keep me here until 4 o'clock? Yeah,
Lord.
no. Yeah. I've read the papers.
As your lordship pleases.
I've read the papers.
But that's what we propose.
Yeah. So what you can do is you can do a summary of your submissions. If I have questions, I'll ask.
As your lordship please.
But I don't think I want to sit and hear what I've read already.
As your lordship pleases.
Yeah.
May I proceed, my lord? Lord, we've prepared a hard copy bundle of authorities that I beg leave to hand up, to which we will refer. And my learned junior tells me that, your lordship's registrar has also got an electronic copy of that, my lord.
Yeah, I've received it.
As your lordship pleases. Lord, as your lordship indicated that you've read the heads of argument, I'll just emphasize a few submissions that we make. The fact that we don't refer to the rest of the heads of argument in oral argument, I ask your lordship not to draw an inference from that we don't persist with those submissions. That's not specifically mentioned. So, my lord, we just emphasize at page 5 of the heads, paragraph 7, the first two subparagraphs of the pre-trial order, my lord, which actually develops in our submission into a sort of...
You're saying page?
The heads of argument, page 5, paragraph 7.
Yes.
So the issues that I'm not going to read to your lordship emphasize in paragraphs 8 to 10 of the heads of argument that the VCF is actually defined in terms of words in the animal health regulations. So just that, if your lordship can make that note. And then, my lord, from page 7, paragraph 12 up to paragraph 30.2, we deal extensively with the Sanction 5 of the Civil Proceedings and Evidence Act, B29. Your lordship will find it at the bundle, page 291. Because why I do that, my lord, all the old legislation was published in either the Government Gazette or the Provincial Gazette. And Section 5, does your lordship have that? 291.
Yes.
Section 5, sub 1, judicial notice shall be taken of any law or government notice or of any other matter which has been published in the Gazette or the official Gazette of the Territory of Southwest Africa. Sub 2, a copy of the Gazette or of the said official Gazette or a copy of such law, notice or other matter purporting to be printed under the superintendence or authority of the government printer shall on its mere production be evidence of the contents of such law, notice or other matter as the case may be. Then, my Lord, just page 7 of the heads, paragraph 12, I quote, or we quote, the section 16(1) of the Animal Diseases and Parasites Act 13 of 56, my Lord. And that section is duplicated in identical form in the proclamations and so on that followed thereafter. And the only emphasis that I put on it, that in terms of section 16(1), it's the minister who has to take the decision to put up the fence. I'll come later to the Animal Health Act, which gives that decision to the chief veterinary officer. And there's some point made of that, my Lord. Just, my Lord, I'm not going to read it. May I tell your Lordship the history of that legislation? In 1956, the first act came, had a section 6(1) in. That is, at that time, South Africa was still a union. And then that act didn't apply to Namibia. Therefore, in Namibia, there were two proclamations promulgated. The first one is in 1958, and the second one was in 1959. But they were identical to the 1956 legislation, my Lord. And then the further chronology in 31 May 1961, the Union of South Africa became the Republic of South Africa. And then, my Lord, we make a point here at page 8, paragraph 17, that it is a notorious fact that there was a foot and mouth disease outbreak in Namibia, then Southwest Africa. Is it a
notorious fact or is it a historical fact?
Now, my Lord, I mention it because I'm going to refer your Lordship to the transcript. That's not really denied by Mr. Amupanda. That's why I'm referring your Lordship to it. There was an outbreak in 1961, the spreading of which was contained in 1964. Accordingly, the probabilities are overwhelmingly that the VCF was erected in terms of the Animal Diseases and Parasites Ordinance 34 of 1959 between 1961 and 1964. Transcription. My Lord, we made just a small bundle extract from the transcription. This one to the court, copy to the other parties. And my Lord, it's just an extract of all the passages in the transcript to which we will refer, my Lord. And your Lordship find the relevant passage at page 175, lines 30 to line 175 of the transcript, where the following is recorded, my Lord. Government says, it starts at line 28, I think, my Lord. Government says that the sole purpose of the line is to control foot and mouth disease from the north to the south. Yes, it's common cause. Yes. Now let us look at the chronology of what happened as far as outbreak is concerned. Do you know or do you not know? If you do not know, then say so. If you know, confirm it, please. Between that will be the evidence. On behalf of the defendants, between 1961 and 1964, the biggest outbreak of animal disease ever in Namibia has occurred. It was in the Eastern Windhoek district. And then, my lord, what follows thereof, one can only describe as a refusal to answer that question. So we submit Mr. Amupanda can't deny that. Then, my lord, the next piece of evidence in the chronology, my lord, is then in 1973, my lord, came the Animal Diseases and Parasites Amendment Act 9 of 1973. That's an important piece of legislation. There was definitions inserted in that act, and your lordship will find that at page 8, paragraph 18.1 of the heads of argument. It first says the Republic includes the territory. Secondly, over the page 9 of the heads, my lord, state includes the administration of the territory. 8.3, state land includes land of the administration of the territory. And territory means the territory of South Africa, Southwest Africa. The paragraph 19 of the heads, the Animal Diseases and Parasites Amendment Act 9 of 73 repealed the Animal Diseases and Parasites Ordinance of 34 of 1959. And that 59 ordinance also repealed the 58 ordinance, my lord. But every time there's a repeal of legislation, what was done in terms of the repealed one is saved as valid. And that successively goes on, my lord. And we make those allegations or those submissions as we go on. Then, my lord, the heads, paragraph 9, paragraph 21, page 9, paragraph 21. That submission there is maybe not very cautiously made. What we really mean there, my lord, is that we are dealing here with a legal presumption. And may I refer your lordship to the Rally for Democracy case in the bundle, page 157. Paragraph 46, my lord. It reads at the foot of the page, the presumption, commonly known as the presumption of regularity, is encapsulated in the maxim omnia praesimuntur rite esse acta, donec probatur in contrarium. And the translation your lordship finds at the footnote 88. It means all official acts reformulate that submission in paragraph 2 so that we rely on the legal presumption there.
In paragraph?
Page 9 of the heads, paragraph 21.
Yes.
And we, as I understand the transcription, and I'll give you, lordship, the references, that the plaintiff on the cross-examination conceded that the VCF was retained under the pre-constitutional legislation. And the references in the transcript, my lord, Your Lordship will first find it at page 27, lines 14 to 18. That was the opening address. And finally, my Lord, it is admitted that the veterinary cordon fence or the red line has been elected, which should read erected, my Lord, in Namibia before the independence of Namibia, and is today being retained. Those are admitted facts in the opening address, my Lord. Then, page 129, my Lord, line 20 to 21. Yes, it is admitted that the red line is being retained. 30, line 21, but the decision to retain exists. Unfortunately, I cannot tell you the specific year. It is admitted even by yourself. Yes, it is admitted that the veterinary cordon fence is being retained. Yes, by this government you have accepted that. So if you have accepted that it is being retained, it means somebody have taken the decision to retain it. It is that decision to retain the veterinary cordon fence that we seek to review and set aside. And then again, page 175, which I've already read to your Lordship. There he says it's common cause at page 175. And then, my Lord, also, if your Lordship can make a note next to paragraph 21 of the heads, this is also a fact that's not in dispute in terms of the pretrial order, paragraph 4.10, my Lord. That's the one in quotations, my Lord. I couldn't find, your Lordship made the latest pretrial order. I couldn't find one that was paginated. Lord. That's why I refer to the paragraphs. The order itself also doesn't have pages, Lord. So I beg your Lordship's pardon if I'm not more specific in this regard. But yeah, I've given that, 4.10. Okay. Right, my Lord, but so that's the legislation. Then, my Lord, we deal with the Constitution, Article 140 at page 10, paragraph 25, and then the heads, paragraph 10, paragraph 20, page 10, paragraph 28. In terms of section 21(1)(c) of the Animal Health Act, the Chief Veterinary Officer may cause a fence with gates, grids, or other passages to be constructed along, on, or across public or private roads, or along the boundaries of, or on, or across any land for purposes of controlling animal disease. And then, importantly, my Lord, page 11, paragraph 29, in terms of section 37(2) of the Animal Health Act, any regulation made or anything done under the Animal Diseases and Parasites Act 13 of 56, which could be made or done under a corresponding provision of that act, is deemed to have been made or done under that corresponding provision. Thus, the VCF erected prior to the Animal Health Act is deemed to be erected by virtue of section 21(c) thereof. Lord, if your Lordship is inclined to make a note there at the end of paragraph 29, so we rely on not on the decision so much of the Chief Veterinary Officer for the VCF. We rely on Section 37(2) of the Animal Health Act for the VCF, because that was done before that act. And when the 56 legislation was repealed, it was saved. The VCF was saved, as it were, erected in terms of the repealed legislation. As your Lordship pleases. Then, my Lord, we, from page 11, paragraph 31, we make the point about the fatal inherent conflict in the plaintiff's case. We deal with a mareless seafood case, which we submit is clearly in point. I'm not going to take your Lordship through that. We make the conclusions at page 16, paragraph 34. And I'm only going to read from the 7th line in that paragraph. The ground for the decision of mareless seafood is this: even unlawful administration action is capable of producing a legally valid consequences. For as long as such unlawful administrative action is not set aside by a court of law, thus claiming an order founded by the unlawfulness or invalidity of the administration action without at the same time claiming the setting aside of the latter on account of its unlawfulness or invalidity, creates an incurable conflict between the order claimed and the existing law, which the court will not tolerate. It is submitted that this ground for the decision in mareless seafood applies with stronger force in this case because by virtue of Articles 140 sub 1 and 3, read with Article 25 of the Namibian Constitution, existing legislation predating or postdating the Constitution remains in force together with anything done thereunder, even if inconsistent with the Constitution, until repealed or repudiated by Parliament or declared unconstitutional by a competent court. And here, my Lord, we refer your Lordship to the Minister of Finance versus Hollard matter, B at B93. I must pause here.
Can I just get clarity on that? You are saying the line you started reading from. Thus, claiming an order founded by the unlawfulness or invalidity of the administrative action, without at the same time claiming the setting aside of the latter. When you speak of the latter, what is it that you are referring to?
Administrative conduct, which is, if you have administrative conduct which is claimed to be invalid, yes. It's the Doornkraal, Ouderkraal principle. Until that administrative conduct is set aside, it's valid, it's enforceable. And even if you say...
but well, you see, that principle I follow. My understanding of what you are... I thought you were referring that even if you have an administrative action, it's normally authorized by legislation. No. Therefore, if you want to claim the invalidity of the administrative action, you must first challenge the validity of the legislation. That's what I thought you were referring to. But this is not what is said here.
Which line is your Lordship?
Okay. From the end of that paragraph, 1, 2, 3, 4, 5, 6, 7, 8.
Is it in paragraph 34?
Yes.
Where I state the ratio, thus claiming an order founded on the unlawfulness or invalidity of administrative action without the same without at the same time claiming the setting aside of the latter. That means the administrative action.
You see, this is what I'm saying. Is it the action, you see, shouldn't you first challenge the legislation?
Without, may I give an extended definition to latter?
Yeah.
What I'm saying is, without at the same time claiming the setting aside of that administrative action.
Okay.
That's what I mean.
Okay. You can proceed.
As your Lordship pleases. My Lord, I refer now to page 93 in the authorities bundle.
Yes.
Lord, and I have to pause here, my Lord. I must acknowledge that in the Rally for Democracy case and this case, I got from the heads of argument for the 6 to 8 defendants. So I just acknowledge that, my Lord. And I read further from from this case, my Lord. Paragraph 95. The opinion that the correspondents have about that the respondents have about the unconstitutionality of the NNRCA, I think it's the Namibia National Reinsurance Corporation Act, does not make them immune to the enforcement mechanisms it provides unless a court makes such a finding through due process of law. The respondents labour under the belief that the view they take of the unconstitutionality of the NNRCA entitles them not to obey it. That issue is not properly before us and we need not express any view on it. Now, it is a proposition that must be tested before a court where the enforcement mechanisms are prayed and in aid. 96. Only a court properly seized with the matter will be able to consider whether such a defence should prevail, if regard is had to the fact that the law being disobeyed was previously challenged and validated by a competent court and has been the law of the land for over 20 years unless and until it is one day reversed by a competent court. So, my Lord, even if Meerlist and Oudekraal deals with administrative conduct, our law extended that application of that principle to legislation as well. That's our point.
Doesn't the Constitution say every law passed by Parliament is deemed to be lawful and valid until set aside by?
Yes,
that's a constitutional principle, so it doesn't have to rely on meriless and.
That's why we say the principle applies with stronger force when it comes to legislation. Then, my Lord, page 16, paragraph 35, the relief claimed by the plaintiff will bring the judiciary on the one hand and on the other the Parliament and the executive in direct conflict. The VCF may be removed today in terms of the orders claimed by the plaintiff, only to be re-erected tomorrow in terms of the Animal Health Act. This is courting civil war, as it were, between the judiciary on the one hand and the legislative and executive arms of the state on the other, the anarchy of which is too unacceptable to contemplate. Then, my Lord, also important is at page 17, paragraph 36 to 39, it's the subsidiarity principle, my Lord. 36, never anticipate a question of constitutional law in advance of the necessity of deciding it. Never formulate a rule of constitutional law broader than is required by the precise facts of to which it is applied. Lord, but the strong point there is our Supreme Court, Lord, paragraph 39, In practice, where a matter is capable of resolution by applying the principles of the common law or the provisions of a statute, the need to interpret the Constitution is obviated and becomes unnecessary, as the application of the subsidiary law can and should provide an adequate remedy. Lord, then over the page, put differently and simply, subsidiarity in litigation denotes a ranking of enforcement of laws where the Constitution as the supreme law is only invoked because there is no adequate remedies in either the common law or the relevant statute. Thus, where it is possible to decide a criminal or civil case without reaching a constitutional issue, that should be done. That's our law. So, then, my Lord, we move on to page 21 of the heads. I'm not going to read that to your Lordship. I see where are we now? Half an hour, okay. I'll read that to your Lordship. Paragraph 50 of the heads. It is admitted that in determining the content and meaning of the right to dignity, the court should have regard to Article 63(1) of the Namibian Constitution, which provides the National Assembly as the principal legislative authority in and over Namibia shall have the power, subject to the Constitution, to make and repeal laws for the peace, order and good government of the country in the best interest of the people of Namibia. And then 51, it is unthinkable that the founding fathers of the Namibian Constitution were unaware of the vast body of existing legislation regulating the movement of animals, their meat and meat products in order to control and prevent the spreading of infectious animal diseases in Namibia. It is unimaginable that the founding fathers of the Namibian Constitution intended, by entrenching the right to dignity therein, to outlaw any regulatory legislation which provides for the stopping and searching of motor vehicles for raw meat, and if found, the confiscation and destruction thereof, should such measures to a small degree adversely affect the dignity of a person. Giving such wide meaning and content to the right to dignity would make it impossible for the National Assembly to make laws for the peace, order and good government of Namibia, including legislation to control and prevent the spreading of infectious animal diseases. Then, my Lord, we refer in paragraph 52 to the Charlie case versus Attorney General. I'm just going to make the one point. It's a judgment, I believe, by His Lordship, Mr. Justice Smuts, where he says in that footnote that's quoted there, my Lord, 36, that if the legislation is constitutional, everything done in accordance with that can't be as stated there. This is akin to the constitutional permissibility of the exposure to such indignity as suffered by all persons subjected to lawful criminal proceedings, for instance. In other words, what he says, my Lord, is if the empowering legislation is constitutional, everything done in terms thereof is intended to be suffered, even if it to a certain extent impacts on the dignity of a person. Lord, then again, with acknowledgement to the heads for the 6 to 8 defendants, I refer your Lordship to the Medical Association of Namibia case in the bundle, page 90, paragraph 34.
9019.
90. Paragraph 34, my Lord. The applicants have not in this matter demonstrated how Section 31(3) of the Medicines Act disregards the intrinsic worth of the medical practitioners or disrespects the intrinsic worth of the medical practitioners or is inconsistent with respect for the intrinsic worth of the medical practitioners or the state does not realize that it exists for the sake of the individual. The state exists for the sake of the individual, but it is also correct to state that the state must act in the interest of the greater majority, reconciling and balancing the conflicting interests of the people in a reasonable, just and fair manner. The following statement by Stradom C.J. in Miller versus President of the Republic is thus apposite. In order to govern a modern country efficiently and to harmonize the interests of all its people for the common good, it is essential to regulate the affairs of its inhabitants extensively. In my opinion, the policy and object of Section 31(3) of the Medicines Act is to regulate the selling of scheduled medicines, regulating the professional activities of medical practitioners, I must say, is for the common good of the Namibian people. There is nothing unreasonable, unjust, and unfair in the challenged provisions, and I hope that the licensing scheme does not infringe the indignity of the applicants.
I've read the heads of arguments of the 6th and 8th defendant, where they say, although, and why I'm smiling to you is that Mr. Heathcote appeared before me and he challenged me on those statements. So I don't know whether he'll agree with you.
Lord, we say it's applicable, maybe not in that Medicines Act, but in the matter before your Lordship. It's true, but it makes the point that even the right to dignity is not free from regulation. To a certain extent.
Yes, the way I've understood that is that the whole issue of dignity, the dignity of any human being, must be determined with regard to the intrinsic worth of that's the essence of it. Yeah, and I have had no evidence on the issue of the intrinsic worth of the individuals that have been.
We don't.
In that case, yeah.
Lord, we wouldn't labour that point. And then just over the page, 23, paragraph 54, my Lord, we just emphasise there that it was conceded under cross-examination that the sole purpose of the use of the VCF is to control animal disease.
It was conceded. But I've read the plaintiff's heads of arguments too. That Ntinda argues that the VCF, the Veterinary Cordon Fence, is a pivotal tool. It's a pivotal tool for the oppression of the majority of the people. So what do you say to that?
Lord, it's for your Lordship to look at the legislation and the evidence presented. The only evidence presented is what happened at the checkpoint on the 17th of May 21. Further, there's no evidence about pivotal issues and for other purposes. So your Lordship, to determine the purpose of the legislation that's impugned, your Lordship to read the Act and the regulations. And there's no evidence whatsoever outside the legislation as to what the purpose of we've got the speeches of Mr. Amupanda on that, but there's no evidence.
Right.
Lord, if I may say so, the rest of our heads, with respect, is Fundamental Human Rights Law 101, Lord. I'm not going to tire your Lordship by repeating that. But before we ask for the relief, we would like to address your Lordship on onus. And then there we would like to start by reference to the pleadings, my Lord. I'm not going to take your Lordship through it. I'll give your Lordship the references. In the particulars of claim, page 11, paragraph 27.2, page 12, paragraph 29.2, page 14, paragraph 34.1, and page 15, prayer 1. It's a refrain. What is done in respect of the VCF? There's not any law sanctioning that. That's the refrain. That's the case of the plaintiff in the founding papers or the particulars of claim. And then, my Lord, we refer your Lordship to our pleadings, page 30, paragraph 47.
Where are you?
Pleadings, page 30, paragraph 47.
In which bundle are you?
Pleadings bundle, trial bundle.
The trial bundle, it's volume 1 of 16.
It must be volume 1. It's where the pleadings are.
Just hold on.
Volume 1, my Lord.
Is it in that? Is it in annexure B?
I believe so, my Lord. Does your Lordship find paragraph page 30 there?
Is it the amended plea?
Amended plea, not the amended plea.
Amended particulars of claim.
I'm not referring to that. I'm referring to 1 to 4 defendants' plea.
Plea.
Yeah.
First to fourth defendant's plea.
Yes, ma'am.
Paragraph, page 30.
Page 30, paragraph 47.
Yes.
In that paragraph, my Lord, we, in our submission, put the plaintiff on terms to discharge the onus to prove infringement of rights. We say the first 4 defendants deny that the fundamental rights and or freedoms in terms of the Namibian Constitution of the plaintiff or others are infringed or limited by the conduct described in these paragraphs. So we in our plea, put the plaintiff on terms to discharge that onus directly, and then we give the sanctioning legislation in paragraphs 48, 49, and 50. We say on what legislation we rely, and then, my Lord, if your Lordship turns to the replication of...
I just need to be a little bit, so that the way I understand that Ntinda's argument is that he says, at the pre-trial, you all agreed, or the parties agreed, that Namibians have historically been subjected to inhuman treatment, and that at the pre-trial that some of the actions may be discriminatory. So, and he says that admission then triggers in the duty, the admission in the pre-trial triggers in the duty on the defendants to discharge.
Now, with respect, he says it's triggered in by paragraph 51, to which I'll come.
Paragraph 51
of the plea, first to four defendants plea.
No, I'm saying what the Ntinda is, the way I've understood
Well,
it.
we'll come to that if that argument comes in reply. Our initial reaction is that those allegations of what happened in the past and even the admissions irrelevant. We're now dealing with what happened at the checkpoint 21 May 2021.
So, but there's no admission that what happened on 17 May 2021 was discriminatory and unconstitutional.
No, we don't admit that. All we say is your Lordship has to accept the version of Mr. Amupanda as to what happened there for purposes of the application for absolution. That's what we say. But we don't admit that what happened there was infringement. So, my Lord, I refer to the replication. Which you'll find at page 62, my Lord.
It's 62 of?
62 of the pleadings, my Lord. First volume.
Yes. Yeah.
Your Lordship will see there it's just a joiner of issue. So there's no, so it's a blank denial, if I can put it that way. One would have expected that if the plaintiff wanted to come to court and prove that those legislation that we referred to limits or infringes his rights to dignity, equality, and freedom of movement, he would have said it here. He would have pleaded it here. He would have pleaded there's no legitimate purpose for that. Or he would have pleaded that there's no rational connection between the means and the ends. Or that there's no proportionality. But it's just a blank denial. So what we submit, my Lord, is the plaintiff is not out of the blocks to shift the onus to justify on the defendants. And what we say in 51 is, my Lord, and that is what the plaintiff doesn't point out to your Lordship, is 51 of our plea says the following. The conduct complaint...
Page 51 of your plea is on what page?
Page 30. 51. 30, paragraph 51.
Yes.
What we say there is the conduct complained about by the plaintiff in this paragraph is in any event, that's what we emphasize, in any event, permissible that at the very least, my Lord, in any event must include the event if in the event that you prove that your rights are infringed, then we plead this justification. That's the plea. In our submission, that doesn't attract an onus to justify. It's still the onus to prove the limitation, which the proof of which would put us on on the onus to discharge, the onus to justify.
Putting it, maybe the onus to prove the breach or the invasion of the right, not the limitation. The limitation comes once it's established the infringement.
Yes.
Yes.
Then the onus to...
The way you were putting it was upside down.
As your Lordship said, only then the onus to justify shifts to us. That's our point. So, my Lord, we are going to refer your Lordship to 3 cases in that regard. The first is in the bundle, page 40, the Alexander case.
Yes.
Paragraph 122, my Lord. And what is important here, my Lord, it's the same judge that wrote the judgment in the Africa personnel case. Your Lordship will recall in the heads of argument for the plaintiff, they set store by paragraph 665 of the Africa personnel case by His Lordship Mr. Justice Strydom. Now the same judge says few, not so much time thereafter, he says, in regard to the onus of proof, I find no reason to distinguish this case from what was said by this court in the matter of Africa Personnel Services Supra, namely that the person complaining that a constitutional freedom of his or her has been breached must prove such breach. Once this onus is discharged, it is for the party relying on a permissible limitation to prove that the limitation falls within the scope of what is permitted in terms of the Constitution. So the passage on which the plaintiff relies for that authority is not correct. Then we refer, my Lord, to the Armadillo case. It's also a judgment by your Lordship at page in the bundle of authorities 199 to 200, my Lord.
Yes.
Well, your Lordship wrote this judgment, and Lord, I'm not going to read everything, but the point is here made. This is authority for the proposition that before the onus, it makes a difference between onus to discharge, to prove limitation of rights, and the onus to justify. And before there is no proof, or if there's no proof that there's a limitation, the onus to justify doesn't shift to us. That's the import of what is said here. So we say they don't even plead that. So they're not out of the blocks on shifting the onus to us. Then, my Lord, the last judgment is at B, in the bundle, 45 to 47. And in our submission, with respect, the law on onus is there correctly summarized by His Lordship Mr. Justice Olin. And I'm only going to read to your Lordship from page 46 in the bundle, between the letters B and C. In both cases, we are dealing, that's now cases which rights that do not fall under Article 21 of the Constitution, and human rights falling from, I think, paragraph 6 to Article 6 to 20 of the Constitution. But he says in both cases, whether we are dealing with a fundamental right or freedom, the applicant will have the burden to allege and prove that a specific fundamental right or freedom has been infringed. This will necessitate that the applicant must also satisfy the court in regard to the meaning, content, and ambit of the particular right or freedom. Then he gives the references, but I emphasize, my Lord, it's the Namunyepo case which deals with dignity, and he refers to the S versus Fries case, which also deals with dignity, and then the Kauesa case, which deals with freedom of speech, my Lord. And then he continues, in regard to fundamental rights, the burden of proof remains throughout on the applicant to prove that the fundamental right has been infringed, at least in regard to all those fundamental rights where no express qualification or exception is provided for in the wording of the fundamental rights, such as in Articles 6 to 12, 14, and 18. But, my Lord, important, dignity and equality is here referred to, 6 to 12. So the onus in respect of dignity and equality is all the way through on the plaintiff. Where an express qualification or exception is provided for, as in our Articles 13, 17.1, 20, sub 3 and 20 sub 4, the burden of proof may shift as in the case of the fundamental freedoms, but the question has not been argued and need not be decided in this case. That also applies in the case before your Lordship. And then he continues, the position in regard to the burden of proof in cases of alleged infringements of fundamental human rights is the same in Zimbabwe, where the Chief Justice said in Catholic Commission versus Justice and Peace versus the Attorney General, I consider that the burden of proof that the fundamental right of whatever nature has been breached is on him who asserts it. And then he also refers to the Van den Berg case there, my Lord, which also deals with dignity, and it's also a judgment by His Lordship, Mr. Justice Olin. The point is, His Lordship, Mr. Justice Strydom, in that Namunyepo case, refers uncritically to this Van den Berg case on onus. And then, my Lord, we continue. In the case of the fundamental freedoms provided for in Article 21 of the Namibian Constitution, the evidential burden is on the person alleging an infringement to prove the infringement, and as part thereof satisfy the court in regard to the meaning, content, and ambit of the fundamental freedom. This initial onus corresponds to the initial onus referred to by Chaskilson P. in the decision of the South African Constitutional Court in S versus Makwanyane. Your Lordship will recall Makwanyane was to abolish the death penalty. Even when it deals about death, the onus was on the applicant to prove that there was limitation of his rights, even if it's that obvious. And then, my Lord, once the initial burden is discharged, the burden then shifts to the party contending that the law, regulation, or act in question providing the exception or qualification falls within the reasonable restrictions on the freedom provided for in sub-article 2 of 21. Lord, I know the judgment of His Lordship, Mr. Justice Olin, in the Frank matter has been criticized many times on other points, but we couldn't find any case where he was criticized on his exposition of the onus in this case. And we would submit that your Lordship can safely follow it. Lord, I see our hour is gone. I'm not sure. At page 30, my Lord, of our heads of argument, paragraph 86, we ask for the following order. Page 30, paragraph 86. The defendants are absolved from the instance, and 2, the costs are reserved pending the appeal against the protective cost order made on 25 October 2024. These are our submissions so far, my Lord. My Lord, I see it's over 11 o'clock. Would your Lordship like to take an adjournment? 15 minutes, we suggest, my Lord.
Let me hear from the people in the same circle as I am.
My
That's a
Lord,
circle of the seniors.
I want to move, my Lord. Don't restrict me, please. Yes, can we have an adjournment?
All right. 15 minutes?
That's fine, man.
It's my watch says 11:20. Can we be quarterly if we can be back at 11:35. Could you rise? Yes, Mr. High Court.
Please you, my lord.
You said I mustn't stop you.
No, my lord. I was saying tongue-in-cheek because I will deal with freedom of movement. Everything, if I don't get an adjournment, then my dignity is certainly not violated. But your lordship granted. My lord, may we make and try and speed up the process with reference to our heads, which I will not read. We respectfully submit your lordship has any one of 4 constitutional bases on which the absolution application should be granted. The first one is separation of powers and the court's reluctance normally to deal with political controversies. And this is a political controversy. And my lord, one can readily accept that when you read and we read the application papers and the protective cost order, one may have, and because paper is so patient, one may have come to a conclusion, although that is still a debate in the appeal court, that there was some, not a political case before your lordship, but one would also submit readily that after having listened to the political speeches, that the real scruff of this case has been exposed as one of political nature. And as a separation of powers issue, Mr. Amupanda should fight his battles on the political field. The second basis, my lord, is a pure one, and you may also choose to grant the absolution on constitutional prospectivity. It is a principle which is just ignored, and we quote the authorities. However bad our history was, and however common cause those atrocities are, that they would took place, common causes there may be on the pleading, the Constitution is not backward looking in the sense of declaring 1896 Germans under a tree unconstitutional, assuming for the moment it was proven. The other principle is constitutional subsidiarity, which we deal with. Your lordship may choose that ground to uphold the absolution. And fourthly, my lord, just as my learned friend for the first to fourth defendants discussed in more detail, just the misunderstanding of constitutional owners. There is this, and your lordship was referred to the case of medical doctors where your lordship discussed dignity. Now the case wasn't overruled on that principle and the objective grasping of the issue. It was overruled on different principles. When I walked here this morning and we had to stop at the green robot where the man which would permit us to walk over the street turned red, I thought by myself, is this a violation of my dignity? Can I just not move on and walk in front of the cars and then come and ask your lordship perhaps in passant during the day just to order the breakdown of the traffic lights? Because that is really what the attitude is. But on a rudimentary pleading evidence level, I will deal with the issues shortly in 3 grounds. And the first one is, every time we look at a prayer, my lord, your lordship will ask, when? Which one? Where? How high? What are you talking about? Which line are you talking about? That's the first question which we will ask in respect of each and every prayer. And in looking at this relief, one asked a simple question: what happened to Mr. Amupanda? And he told your lordship a story, what happened in May of 2021, where he came from the north and people asked him whether he has meat in his car. They took it according to his version, and we know that the regulation says, and my learned friends for the first to fourth defendants quoted that you may not bring that meat over. After that, he left on his way to Windhoek. How on earth was his dignity violated? And the test is not, as Article 8b wants, my lord, a little limitation on your dignity where you've got the full onus, as Namanjepu says. The court will interfere if dignity is violated. Of course, when I go to jail for whatever I might think of, my dignity is not violated. People murder, go to jail for 20 years. Of course, their movements are a bit infringed, but certainly dignity is not violated. Otherwise, we couldn't send people to jail. The whole basis of law and constitutional law, unlike political science, it seems, is we have a bit of logic in it. Now, the third issue, my lord, is eventually I will ask your lordship that it is now time to give Mr. Amupanda leave to leave. He has now done what he came to do, and I have one apology, and it is this to your lordship. We should never have stopped accepting to the pleadings, because we tried, as I've shown to your lordship in the bundle to hand up, which we handed up, to give structure to this case. And we've done about 5 exceptions. Eventually we gave up so that he can just come to court and have his day and speak his speak. And what a disappointment it was. No preparation, no expert evidence. He probably read a few pages of a book from which he quotes half-heartedly and piecemeal, which is still not evidence before your lordship. May I then move to the heads of argument and go to the prayers. And before I do that, my lord, the political science that was tried to be presented in this case has got absolutely nothing to do with geography. One thing which is absolutely clear from his evidence is this misunderstanding. And I'm going to refer, we have handed the transcript up to your lordship. Your lordship may just make a note at page 83 of the transcript. I asked him whether his colleagues tried to assist him and so forth. And here is his answer at line 17. And how I will proceed with my case, I came to court to indicate to court that 1896, a colonial instrument has been put in place. That colonial instrument stayed on through the German colonialism, South African colonialism, and continues. He's always been in this court under the impression that the police zone that is reflected on the 1911 map, and I will deal with that, that is evidence before your lordship where that line is. And it is, according to him, common cause where on his map, on Annexure B to his particulars of claim, where he indicated the VCF. Now, the one thing your lordship can take cognizance and judicial notice of in our submission is that Namibia has a veterinary cordon fence. What your lordship cannot take cognizance of exactly where it is. But a court can read maps, and I will illustrate to your lordship, as we have done with reference to the bigger map, that those are miles apart. His ideology is based on a misconception of historic fact. He thinks, and he said that to your lordship, and I will refer your lordship to it now, that the old police zone with which he has his real gripe is today's veterinary cordon fence. And may he now go from this court realizing that he is wrong. And hopefully the Namibian nation also in the judgment be told what the real position is. I'm referring your lordship just to one other place where your lordship said to him at page 112, first of all, at 112, the question is asked, do you agree that the ideological red line police zone, where it is used to be in 1911 and wherever is not at the same place where the physical fence is today? Say, no, I do not agree. So he comes to court with this wrong conception in his mind that it is the same thing. Or was it a forced one so that he can say something politically? Your lordship then asks at page 113, the question is very simple and straightforward. Does that line, that Lindequest erected in 1890, still exist today? Yes, he answers, the border is still exactly the same. Now, my lord, that is a fundamental misconception, and that I can illustrate to your lordship with reference to the two maps and the proclamation of the one that I've also put to him of 1919. Now, I've asked that the two maps just be handed to your lordship and the regulation. Does your lordship have that? If I may start with a regulation or proclamation then of 1919, and at page 127 in paragraph 2, no person other than an official of the administration shall save under permit issued by or under the authority of the Secretary for the Protected reside or be, and then it says, in the area beyond the line defining the police zone marked on the map of the Protectorate of Southwest Africa of the 1st October 1911. Now, my lord, that is the map which we have handed up of the 1st October 1911 and was handed in Exhibit D, and which is part of the little bundle. And then it gives your lordship an exact description, but the line is on the map, and we've drawn it in for your lordship. It goes from, and this is very important, I hope Mr. Amupanda listens also today, because where does it start? It says, from the mouth of and along the Umaruru River to Nainai, then in a northerly and northeasterly direction to the Etosha Pan, thence along the southern border of the said Pan to Kantasap, thence along Umarambo, Uvamba, and so it continues until it reaches Botswana. Now, if your lordship looks at the map, which is the an extract from the fence, the green line is that line. And that line, my lord, if you want to, we can bring you the original one which we got from the archives, but that's a public document, that's an official document, it is permissible. And the green line, my lord, is the police zone. Now, there is no evidence that there was ever a fence erected on that green line. Nothing. So, if your lordship goes to the other map, which I've handed to your lordship, this is Annexure B, which was attached to Mr. Amupanda's particulars of claim, and which is admitted by the first to fourth respondents in the pleadings, and that is the map. He says veterinary cordon fence, that's the purple line on top, and that is the line which your lordship will see on our map, which we just copied over, is the orange line. The green one, that's the second judge down the aisle at the point. 1932, he says, public maps generally offered for public sale are on similar grounds admissible. And so it is true that there was no evidence of this map. Exhibit B is a published map generally offered for public sale, but on the face of it purports to be a map drawn by the Surveyor General Windhoek. And so he continues. What was admitted and what was this case about was Proclamation 26 of 28 and did deal with the police zone. And the court accepted the map. And that was not even, my lord, the map as incorporated in the legislation which I've referred your lordship to. So it is quite clear, if one asks, when, where, why, how, were you there, that Mr. Amupanda knows nothing, not a single element. And with exposing him as thinking that the old police zone, with all the ugliness he wants to give to it, whatever it was, is not the same as the VCF today, his political case comes tumbling down. And he must know it. And I can't say that he faked it, but he certainly didn't want to answer the obvious truth when we dealt with it. Now, once we know that, my lord, and with the four principles or constitutional principles I referred to, if one then goes to the relief which he seeks, and I respectfully submit, my lord, that some of those relief your lordship will not, on the four principles, your lordship will not even grant, ever, even if we all ask for it. Because your lordship will say, I cannot enforce your Africa before the Versailles Treaty and so forth. My lord, it is an absolutely nothing that he asks. In fact, if you want to do that, to say there is no German law and he can read German, I invite him, he can come to my library. Those are all there since 1886 when the Germans arrived, with Gesetzbuch and what have you. But why would your lordship order such a thing? It is just inimical to the whole purpose of Article 12, my lord, which we come to court for civil rights and obligations to be determined. He wants your lordship to say, Mr. Lindequist had no law when he stood under a camel thorn tree in 1896. What joke is that? You find at paragraph 43 of our heads of argument, an order declaring that the erection of the veterinary cordon fence is unconstitutional. Now again, he's got veterinary cordon fence and red line. We know, my lord, that what he refers to is the police zone. And that was on his own ill-informed version, erected, assuming, in 1896. Now, what does the Constitution turn around to 1896 and declare things unconstitutional? Lindequist was a German and he was a bad one. And the Constitution says so. Prayer 3, an order reviewing, that's at page 24, paragraph 49, an order reviewing and setting aside the decision of the first and second defendant to retain the veterinary cordon fence. With due respect, my lord, there is nothing, no evidence what is common cause is that it is still there and was retained. But it was retained by Article 5 of the Constitution. Your Lordship cannot set aside, Article 5, Schedule 5 of the Constitution. Your Lordship cannot do that. One must remember in this Constitution of ours, my Lord, it's not like in Australia where the settlers are there still and you have original people fights and original people rights, and where the Australian courts rely on universal rights and so forth to determine the controversy between the Australian state, which was there and which came there by Thomas Cook, dawn in 1990. Your Lordship will recall the Buster Gemeente case. They were involved in the constitutional negotiation process. The people of Ovambo land were involved in the constitutional negotiation process. They are politically entitled to vote for anyone and get their politicians to remove the fence if they be so foolish, without, just on a good day, without checking animal diseases and so forth. But if you have such political aspirations, let you be the court, you may be the court's case, but the court will not on any of the four principles assist you. So the relief, my Lord, setting aside the decision of the first and second to retain. Now the first defendant is the minister, and the second defendant is the government of the Republic of Namibia, which existed on 21 March 1990. It's got nothing to do with SWAPO or any other political party. It is the government. It is the representing. There's so many out there, people that think SWAPO and the government is the same thing. Perhaps, my Lord, somewhere we need to explain. Surely a political scientist must know that, but it seems that he doesn't. I was wondering whether political science, by itself the science, has rationality tests, because in law we have. So the erection has not been carried out. That's 2. I've dealt with 3. An order reviewing and setting aside the decision to retain. The Constitution did that for us. But prayer 4, an order declaring that the conduct of the 4th defendant, that's now Nambinga, in confiscating the red meat of the plaintiff is unlawful and unconstitutional. Now there your Lordship can move ouderkraal, subsidiarity, what have you, because we know on the common cause fact he was a veterinary officer and he was stopped and there was no evidence whatsoever that he had a permit. In fact, it is so obviously patent that it was planted to trigger a political case. But of course your Lordship does not have to find that for purposes of absolution. My Lord, it's often said in absolution applications the court will not make credibility findings. But here I submit there is of course an exception to the rule. This man, my Lord, the plaintiff, got into that box. He pleaded for over years. He was submitted to this degrading exercise of standing continuously on mats and being searched. When he gets into the box, he tells us he saw or realized for the first time on that day that there is a veterinary cordon fence. Now, my Lord, with respect, not a child will believe that. I move to is it 6? 5. An order directing and restraining the government, sorry my Lord, that's paragraph 57, page 25. An order directing and restraining the government and or its officials from confiscating red meat of the plaintiff or any one of us. He wanted to just have a bit of equality, not only himself, meant for private and own consumptions. I've demonstrated through cross-examination this, whatever you call it. You come to court and say, will you please interdict the government and its officials to do its job? My lord, it's like me coming to court and interdicting the police never to arrest me. Doesn't matter what I'm going to do in future. Perhaps my dad is not Biden and I will not get nice, loose, just pardons. But the court has never, ever, I've never seen a court interdicting by blanket mandamus interdict, prohibitory interdict, the government such relief in a court of law. But the best, my lord, is probably saved for last. An order directing and compelling the first and second defendants to immediately, and we'll give you some leeway to get your yellow machinery there, remove the veterinary cordon fence, assuming, my lord, it's the one on his map. Now, look at this with due respect. What happened to Mr. Amupanda? He came from the north, was stopped. This is the case. He came from the north, was stopped at a place which he thinks, mistakenly so, on the facts before your lordship, is the old police zone, and perhaps in his mind's eye, he saw that German officer around the corner there, and suddenly he felt so aggrieved that at the gate where he was stopped, when he looked to the west and to the east, your lordship, I don't know how wide Namibia is it 1,000 k's? And out of pure spitefulness, he comes to court and say, because I was stopped at a checkpoint, break down the fence. And he wants this court to do that. On what evidence? What evidence? And the only evidence which is before this court is the mistaken understanding of an ill-informed political scientist that the old police zone is the same place at the same spot as the veterinary cordon fence is today. It is a case of mistaken identity, for lack of a better word. My lord, there is only one result in this case. There is not a single element made out. My learned friends dealt with the owners. Of course, when a case is so woolly as this one, so woolly pleaded by your own subconscious, ill-informed facts and spurred on by a fearless lawyer, then it becomes so woolly you can actually quote any case and make it applicable. So all we can ask, your lordship, and I've got also fault in that, we should have stopped it in its tracks and asked for it to be accepted and thrown out. But yes, here we are. So, my lord, I agree that while the Supreme Court must hear the case, that your lordship should reserve the judgment on costs. But now that absolution in respect of all the claims by their name be granted, and that Mr. Amupanda can be granted leave, although it's us that must be absolved, can be granted leave, to do what politicians does, and hopefully this time with the correct facts. Thank you, my lord.
You see, because this is a court of record, I would want you to move forward so that you are recorded.
Thank you, my Lord. May it please not only the Lord, but also my Lord. My Lord, I, as you know, have followed the proceedings virtually for the 6th and the 8th defendants, and now I'm here to present the oral argument before your Lordship, and I'm grateful for my learned friends for standing in for me. My Lord, what I would like to do, with your leave, is deal simply with 3 topics. The first is the written argument that's already been presented. The court has indicated that the court has read the heads, and I will not try to read it or repeat it, but it does help to frame the argument. Secondly, I would then like to go to show the court some things that have already been shown without repeating them, and some others. The key, what I call revelations, ellipses, and lapses from the transcript as we now have it. Luckily, it's now been ready. Then, my Lord, finally, I'd like to go a little bit ahead and deal with what we now have as the written argument for the plaintiff, the respondent in the application for absolution from the instance. And, my Lord, then there is something else that has arisen this morning through debate by your Lordship. The court has pointed out to the plaintiff's key argument, and I'd like to address that also on the hoof. And I might, because it is the point that has been identified in oral argument, is why. All of that is, on the pivotal tool argument, in fraudem legis, we do something else with our fence. We don't protect at all against foot and mouth disease. And Lord, the law on that is clear. What one must do is one must establish in fraudem legis. That's Zandberg versus Van Zyl. That's very old law, 1910 appellate division. Now that has been applied in Ellis versus Noah Bebb by the Supreme Court just the other day. And since we have all last week cited judgments in which some of us have appeared in reported matters, not necessarily as counsel, but sometimes as the cited party, this is indeed my instructing attorney, but he's won in that case. But the simple point, my Lord, that was just a little bit of free marketing aside. If one asserts simulation, because the purpose is something else, some other pivotal tool, then one must prove that. And that, my Lord, has been said by the Supreme Court in Hailulu versus Director Anti-Corruption Commission. The citation will provide to the court, but it's 2016, Volume 4, NR 1110, a judgment of the Supreme Court, and it is paragraph 53. What paragraph 53 says is this. The appellant relied on several decisions that are authority for the principle that where a power is not used for the statutory purpose for which it is conferred, but is used instead for an ulterior purpose, the exercise of the power for the ulterior purpose will be declared invalid when, of course, such a case is brought and when such relief is sought. So the Supreme Court then goes on and says, this principle is a salutary one, and indeed it underpinned the High Court's decision to declare the arrest of appellant unlawful. But it does not assist the appellant in relation to his challenge to the Commission's decision to institute an investigation into his conduct. Why not? Quote, the record does not establish an ulterior purpose. Lord, I'm going to take you through the transcript. The transcript does not establish an ulterior purpose. So that's game over. And the correct way to do that, when one applies CAUESA and when one applies Rule 100 of the rules of this court, and when one applies what the Supreme Court itself has ruled, in this case, between the same parties, in a reported judgment which we cite in our heads of argument, which is the minister versus the plaintiff, Mr. Amupanda, then it is absolution from the instance that the court must grant. That is the correct constitutional relief at this stage. So, my Lord, that concludes my last point, my pivotal point, my pivotal 2 point. What I'd like to then just very quickly do Let's just remind the court of what the court would have read in our heads of argument. The court would have seen that we all on this side of the case are united. Article 140, sub 3 of the Constitution is the complete answer. Read with section 21, sub 1 of the Animal Health Act, that completely answers the point. If one then wrangles a little bit and tries to make a different point out, which is what was made out in the opening statement, that there is no court, I beg your pardon, no legislation that says by parliamentary fiat, the court says, there shall be light, there shall be a fence. I hereby declare that I have, from thin air, established that there is now erected a fence. It's not prayer one, but that's the argument. Then one finds that. It is in section 37 sub 2 of the self-same Animal Health Act. It's there. And I'm not going to bore the court with that, but when one applies Mwandingwi to all of that, the binding judgment 1993 by the Supreme Court, in which one finds so many of the constitutional principles that govern today, then one knows what the answer is, and we don't have to take that far further. It is the manifestation, the articulation, the codification, and the amplification of Article 143 of the Constitution. But Article 25 is one to which we see reference being made now in the heads of argument for the plaintiff. But Article 25 is in fact the counterpart of the subsidiarity principle, because what it does is it says in 25 sub 3 that the court will be declaring something unconstitutional. That something is the authorizing, empowering provision, the law. Now, there is no such act impugned, and my Lord has heard that, and my Lord has read that, and that is our case, and we respectfully submit that the point has been conveyed sufficiently. What we say is the manifestation of this point, when one has not impugned the vires, what one then does is one lands straight on this court's judgment in Matungu. Lord, it's Matungu versus Minister of Safety and Security, and it's a judgment that we cite and we deal with in paragraph 21 and footnote 42 of our heads. And we do ask the court read the judgment again. It is a concise judgment, and we say that it is paragraphs 14, I beg your pardon, it's paragraph 11, 13, 14, 15, and 16 that is of absolute fundamental importance. The head note of that judgment: if there is a statutory infrastructure, a statutory matrix, that statutory matrix has to be resorted to. The plaintiff must ask the minister, Minister, I don't like your fence, change it. He must say, Parliament, I don't like your legislation, change it. He must say, Veterinary Chief Officer, give me an exemption. He must say, okay, I can cook this meat, or he could say, okay, I can take it to this abattoir. There's a host of a statutory regime that's been dealt with in writing and orally. Not a single one of that is used. Not a single one of that is suggested not to be good enough. Not a single one of that is impugned. What is done? We don't go to the legislature. We don't go to Parliament. We don't go to the executive. We don't go to an administrative official. Which arm of government do we come to? We come directly to the court. But Ntungu says that that is unconstitutional. It's a cause of action that no scrap of evidence can ever establish. My Lord, there is a second string to this when it comes to Article 8, and that is also answered by judgment of this court. My Lordship has already referred to that and been referred to. It's MAN, Medical Association of Namibia. And the point is simply that he did go on appeal to the Supreme Court, but he did not do anything to what my Lord has held on Article 8. It dealt with matter on a different basis. So MAN stands as good law, and we again rely on that. And what we say is that MAN shows that all the European case law that we cite in our heads demonstrate how the plaintiff in this case has not come close to establishing any infringement of dignity. My Lord has those judgments, Shearing, Kudla, Tyre, MSS, that's cited in our bits of argument, footnote 75 to 79. We've heard nothing about it. We haven't heard that we got the law wrong. We haven't heard that there is actually some other wonderful judgment from South Uzbekistan that rules slightly differently. My Lord, that's the law, and it's very well-known law. The legal faculty at the University of Namibia would have so informed the plaintiff, but of course he didn't walk the corridors. He didn't go to the vets and ask them, what do you say? Why? He says why not. In the transcript he says exactly why not. He says it's only his view that matters. He argued to the court that his view has a little bit changed what his cause of action now is. It's now not that it is unconstitutional, but that it was not the intention of the Constitution to have a fence like this. My Lord, that is of course entirely wrong, because 140 sub 3 of the Constitution makes it very clear what the intention of the Constitution is. But my Lord knows that intentionalism, that's that interpretative exercise that the old judges of the Supreme Court of the United States have always resorted to when they just wanted to do what they wanted. Institutionalism, I beg your pardon, intentionalism is an entirely repudiated method of interpreting a constitution in this manner that we have now seen in the evidence-led viva voce. The plaintiff has sought to now change his witness statement, not to say that it is unconstitutional, but to say that it is not the intention of a constitutional dispensation to do any of these things. My Lord, intentionalism, that's just simply not arguable, but secondly, it's a very radical change from what is actually pleaded. The witness statement has actually been amended so that what he brought us on court to say has now radically changed. We know, for instance, from the second certification case in South Africa, it says very explicitly that constitutions all over the world all do that all the time. They all have transition regimes because one can't let things collapse. That is, many constitutions say so, and we've got a lot of constitutional cases in South Africa that says that. So the proposition that constitutions don't do these type of things is, as a matter of general international principle, entirely incorrect. But as a matter of this country's constitution, it is in Article 140 sub 3, where the court knows that that is, of course, just simply a non-flyer. My Lord, trying to condense what we say in heights of argument, I understand that thousands of pages have been uploaded on e-justice and files provided, but we think the case really turns on 5 judgments. And I'd like to wrap up the section of my oral argument dealing with our heads by simply saying I've already dealt with Mwandingwe. We say that that's the key case on the Constitution requiring Parliament to repudiate past empowering provisions and the exercise of such powers during a pre-constitutional era. The second case that we say is key and is dispositive is Matungu. That's his lordship judgment, to which I've already referred. That is when the prisoner comes to this court and say, I don't want to be in this prison, I want to be in that prison. Please transfer me. But it didn't go to the prison authorities. That is unconstitutional. Then, Lord, the case already dealt with in argument before me is Medical Association Namibia. I've briefly referred to it. That is decisive of the Article 1 dignity aspect of this case. Then the case which has been dealt with already in the opening statement for the plaintiff, that is Namunjepo. That's on Article 8(2)(b), cruel and inhuman treatment. My Lord, I'm going to, when I come to the transcript, just remind the court of what it is that the plaintiff said happens to one. What is the treatment that's being complained of? I've already referred to the European case law, Searing and all of those cases, that says that there is actually a threshold. You can't say, I don't like it, therefore my dignity is infringed, and therefore I've been treated in a way that is constitutionally violatory. One has to reach a certain threshold of conduct. What was the threshold of conduct in Namunjepo that was said to be cruel, inhumane treatment? It was putting somebody who is an unconvicted prisoner, who the court explicitly said has the constitutional right to be presumed to be innocent, to put such a person in chains for 6 months in metals. That person couldn't wash, they couldn't properly eat. It was at a level that is completely in line with the European case law. In the European case law, people had to drink out of toilets, my lord. That's the level of inhumanity that one has to suffer to establish evidentially an Article 8 infringement. We are just not there. What has been said, just to quickly run ahead in the transcript, is that a person must get out of a person's vehicle. That person must stand on a mat. The mat was initially called dirty, then later it wasn't called dirty anymore, and then later it was said you don't even always have to stand on the mat. Then it was said that while you're there on the mat, you must do whatever you must do. That is how the transcript reads. I don't know whether it's the hokey pokey, but there's no evidence what it is that you must do on that mat. What you must do next, you must climb back in your car and you must drive on. Is this like drinking out of a toilet, my lord? Rhetorically we ask that. Of course it isn't. My lord, it is an embarrassment. My lord, I was wrapping up with my 5 cases that I say are key cases. The last one is Miller. That's a judgment that your lordship has applied in Matengu. And that's the one, I beg your pardon, my lordship has applied that in MAN, in Medical Association. What Miller holds...
Decisive case in Downsap, the lesbian issue. That was a decisive case. That's a case of Miller versus the president. Yes.
Yeah, my lord, with respect, what these cases are, what they establish and what they are clear on is where the onus lies. And that is the fundamental flaw in the written argument presented for the plaintiff. Miller makes it very clear that both for Article 1 and for Article 2, the onus is on the plaintiff to establish the various things. For Article 1, one must establish the absence of a rational connection to a purpose. What the transcript shows is that it's conceded that there's a purpose. It's even conceded that it is the sole purpose. So the pivotal tool, the ulterior tool, argument, that is the thing on which my lord has put his finger this morning, is simply inconsistent with the evidence. So it is simply a no-go. So Miller then, I would say, is the final judgment that that the court would use in deciding this. We think that there's 5 judgments. We think that, with respect, the test for absolution is very well established, and everybody has the same tests, and the same authorities on all of that. So we would not ask the court that, but this is what we respectfully submit, a simple, straightforward matter, and that this is where the case ends. My lord, I have already referred, moving on to my second topic, to parts of the transcript. The transcript has also been dealt with already, and with the leave of the court, if we could simply provide the court and, of course, our colleagues, simply with a list that simply lists what part of the transcript we think the court would, if the court is minded to refer to the transcript, which parts the court must, of course, read. We're not asking the court to read selectively, but there will be things that we think is helpful because they are absolutely crucial. What we can do is we can simply make a list without any argument, without any spin, simply say what the reference is, and then what I will do is I will then save some time because I then don't have to go through my entire list and read it out to the court. I've dealt with the issue of what the plaintiff's evidence in chief was. We know what he has pleaded. He pleaded that the red line is unconstitutional. We know that in his testimony he wanted this new version to be recorded. His new version is that it is not the intention of a constitutional dispensation to allow the red line to remain. So that's an invitation for the court to dwell on intentionalism. Intentionalism has been described as highly suspect as a controlling mode of analysis and is not used. It is not used as a neutral guide to constitutional interpretation. So this is a market shift in the case that we've heard, but it is simply something that the court, with respect, cannot entertain. There's not a trial to continue to run on this level at which the new case is now pitched. My lord, the other thing that the transcript, of course, reflects is something that we must not forget. And that is that the plaintiff has spent the weekend before the trial commenced subpoenaing everybody from the entire country, also even in the correctional facilities of this country. that has fizzled. Those essential witnesses were not called. Why is that? Because the subpoena was simply irregular. It was set aside and it was accepted as such, which means simply that the case has collapsed. Now, what was the other great thing that as evidence was sought to be adduced? It was, of course, that document of 164 pages, which we were never told which bit of it was supposed to assist. Now, who was called in support of that? A consultant, Mr. Conradi. He was not the author of the document. Now, how a consultant was going to testify to it and somehow render that admissible could not be explained. So when my Lord then ruled that the document is inadmissible, the response to that was not to enter any objection. It was, of course, to accept the court's ruling. And my Lord, what that does to the case is simply to rip out whatever evidence there remained. So the test for absolution is very simple. When one reads the transcript, it is just that there's just nothing left of this. And it is that when we said that it was unconstitutional as plaintiff and we pleaded that, we just now want to say that somehow intentionalism is something that the court should probe. There's lots of other things, that buzzwords that were flying around in the transcript, like opportunity costs. But my Lord, what does the transcript say has been done? It concedes that government has done a cost-benefit analysis. Government did investigate the pros and the cons. That is, on the transcript, the plaintiff conceded that. What did he do? What evidence did he establish about what is good and what is bad? What does the transcript say? It says that there is no scrap of evidence at all on this. But now the concept that is advanced, the transcript reflects, is opportunity costs. So there's no evidence for the concept that is invoked. Once again, every time a concept is invoked, this is a case of concepts, it's not a case of evidence. But Lord, this is not a motion proceeding. This is a trial. It has to be established by evidence. It was the plaintiff who instituted a trial. Why? Because it is the plaintiff who bears the onus. Now, there's lots of cases that says that, and they've all been rattled off to the court, and quite a few by Justice Olin in the High Court. And we just remind the court of Ranjis. That is the judgment that cited the very first one on our list of authorities. Why we just add that is because it's a Supreme Court authority. And in paragraph 76, it confirms that, which has been said many, many times. It's been said in Miller, and it's been said in the judgment that my Lord has already referred to. The onus is on the plaintiff. The onus had to establish that. And what did he do? He brought a trial to establish that. That means he must lead evidence. It's not a case that turns on concepts that you can bring on motion. And the answer to that, the Supreme Court said in this very matter when it went to the Supreme Court, is if this was a motion, you should apply the rules on absolution from the instance as they reside in the High Court rules on motion. But now this is a trial, so now you, of course, apply Rule 100, which is what we are here for. It is the way to give a plaintiff a dignified opportunity not to destroy the law for any other litigant, so that the court must sit through a trial which will last a very long time because the defendant's defendant's witnesses have not been called yet. So there are 4 witnesses for the first to the 4 plaintiff, if I am correct. Then there are 4 or 5 for the 5th defendant, and then there are 4 for my clients, the 6th to the 8th defendant. They are going to have to testify, and they are going to have to be cross-examined. It is not just going to be quick, my Lord, and that's not because of our conduct, it is because what we have seen last week. We have all seen how slow one can go. And that's by no doing of our own. So, my Lord, the dignified way of not destroying what may one day perhaps be a competent constitutional case is not to grant the effectively leave to continue with this case, because then the court will be confronted with having to dismiss the case in the end after having heard a lot of evidence. The court will be creating a precedent. It means that this topic cannot be litigated again. The way the court preserves that, in the interest of justice, which is the key concept that has not yet been used today, is to grant absolution from the instance. That has been said many times in constitutional court case law from South Africa, and that is the concept that is now governing in constitutional litigation all over the world. We're not asking the court to change the test. We're asking the court, as one does with the interest of justice, to infuse the existing test for absolution with the concept, interest of justice. Is that strange? No, it is not. The plaintiff himself cites authorities which itself uses the interest of justice concept. The problem is, as happens so often, one stumbles upon something that one copies and pastes and throws into a document, but one doesn't analyze what is it that it does to your case. And that is what we read in the plaintiff's heads of argument. The plaintiff's heads of argument tries to persuade the court about the onus and that it somehow rests on us. It then cites the very first judgment, and that, and my Lord knows, makes exactly the opposite, the very opposite point of what the plaintiff tries to establish. It is that the onus is on the plaintiff, and my Lord has already dealt with that with counsel for the first to the fourth defendant. To establish infringement, the onus for that is on the plaintiff. To establish justification, the onus for that is on the defendant. That only arises once the onus is acquitted by the plaintiff. If it isn't, there's just no trial to run anymore. So, my Lord, that is where I am now. That's topic number 3. It's the heads of argument for the plaintiff. And that is Africa Personnel is the opening judgment which is quoted. My Lord will have seen that the crescendo in that quotation reaches something that the Supreme Court itself decided to put in quotation marks. The Supreme Court itself said, we are dealing here with a label. It said that label is, and then it said, quote, police zone, unquote. The plaintiff says in its heads of argument that exactly the same labeling is true of the red line. That is his case. And my Lord, let's then read what the Supreme Court said in Africa Personnel Services. It said, in paragraph 80, the much maligned contract labour system of yesteryear and the more modern concept of agency work may both bear the same label, quote, labour hire, unquote. Supreme Court continues, but in reality, in law and judged by the nature of the employment relationship they result in, they have had very little in common under our current constitutional dispensation. Hence, the support which the respondents were seeking to find in the abusive contract labour system to justify the prohibition of agency work was misplaced. So the constitutional jurisprudence of this country is that you can give a dog a bad name. You cannot hang it. My Lord, that it is so, that there is a public outcry, that is something that is much invoked from the witness stand about the fence. A public outcry is normally something else. That doesn't constitute a constitutional cause. Call it something else. That doesn't constitute a constitutional cause of action, especially not when we know that this thing has changed its purpose. How do we know that? Because the plaintiff testified that. That's what the transcript records. It has changed its purpose, not only its colour and its stripes, it has actually even changed its footprint. That is accepted as evidence. So, my Lord, there is simply, when one then uses and try to leverage some soundbite from the Supreme Court and you actually read what it says, Africa Personnel, it destroys one constitutional case completely. The next case that's invoked in the heads of argument is Alexander. That has already been dealt with. Alexander completely establishes what is entirely uncontroversial. It is that the onus is on the plaintiff. So the heads of argument is revealing because it tries to cast the onus on us. What it shows, my Lord, is a complete clear concession that it cannot continue if the onus is on it. It's then sudden death because it didn't quit itself of an onus because it didn't think it had it. It is a case that is simply legally misconceived. If there is no evidence at this stage, because you've legally misconceived your case, the court terminates it here and now. Otherwise, we waste a lot of time, a lot of money, and the court is required to make a precedent which for once and for all declares this thing perhaps constitutional, perhaps unconstitutional, But perhaps it's not the view of the court that matters. Perhaps this is the view of Parliament that matters, and perhaps that is where the argument must be presented. But it was presented last week from a soapbox that was the witness box. My Lord, I'm mindful of the time, and I'd like to wrap up. Rally for democracy is an aspect that's already been dealt with. We all rally together, we all rally for democracy, and democracy is not served by continuing with this trial. But there is something that the court will also have noticed, and that is the manifestation of the Teletsani principle. The court is mindful, of course, of the Teletsani principle. We all use it as shorthand. It's a 1991 judgment by what we can still call the AD, but it is, of course, because it's reported in 1991, one will always be able to find oneself in older AD judgments that's still binding and good law in this country. But, of course, we know that the Teletsani principle has been applied often by the Supreme Court and also by this court. In fact, it's been applied in judgments that we have already cited in our heads. So I can quickly give that to the court if I can find it, but that's old hat. The Teletsani principle, we know what it stands for. It means that if you say that somebody hasn't given me a fair hearing, I beg your pardon, the principle is, if you claim that somebody didn't give me a hearing at all, and that somebody comes as a defendant in court and says, and I did give you a hearing. This was the hearing on this day and that day. And then that plaintiff comes back and says, oh yes, but that hearing wasn't any good. You were biased, or you should have given me more time. That's the Teletsani principle. The plaintiff makes out a case, a defendant comes to meet that case. One can't then say, now that I know what the law is, I now know that actually Section 37 sub 2 of the Animal Health Act, now I actually don't like it. And I want to say that it's very unfair that I can't take my meat across the border. The point is that if it is, the measure is not good, but the measure does exist, then one must attack the measure. It has not been shown, and that is the very first point that we've dealt with. That is the tool argument, the pivotal tool argument, that this is an instance where something that is said to apply to one thing is applicable to another thing. But that's not the instance, that's simply not the case. So Teletsani stands for the principle that you can't chop and change and you can't move your case. If the regime exists, with regime I mean not a political regime, I mean a statutory matrix, the law governing the topic. If that exists and it's not attacked and you didn't ask for exemption under it, then it means that you can't just now say, I don't like the statutory infrastructure. And throughout the transcript,
go for lunch, we come back at 2:15. But before we go, I thought.
Sorry, my Lord, I'm only addressing my colleague.
Yeah. Before we go, what I think is, in your opening statement, you relied so much on a book I don't know, and I asked you. And I see in your heads of argument, you are again relying on that book.
Yes.
I wouldn't mind having a look at the book.
Yes.
What I'll do is I'll also ask my research assistant to make you a copy of an article written by a Namibian. Let me just quickly see. It's an article that says it's a Mr. A.S. Bishi and Mr. J.A. Kamwe. They authored an article, it's a working paper for, they say transboundary animal diseases and market access, future option for the beef industry in Southern Africa. Institute of Development Studies in Brighton. So I would ask my research assistant to make copies for all of us. You see, so that we see now the historical narratives, what they may bring about. When one, you see, what I want to come out is that as a court of law, one needs to take decision based on facts. History may be important, but still there must be facts and testimony about specific events. Right? 2:15.
My Lord, perhaps also, I have a copy of the book.
Yes, give it to
If
my
I
researcher.
can give it
But
to-
just make sure my colleague, your colleagues see that there is nothing in the book. Yeah, I don't want to make sure there is nothing in the book.
Yes.
It's clean. It's not inscripted. It's not written on.
As the court.
Yeah, because if there is anything, notes on the book, I don't want it.
I understand, my Lord.
Yes. God, then the rest we come back at 7:15.